it was a case that was tried all the way to verdict. For the injured client, it's a really daunting prospect to have to sit on a witness stand under oath in a courtroom in front of a bunch of strangers and answer questions about something so deeply personal. Hi, my name is Scott Occhiogrosso. I'm a partner here at Block O'Toole & Murphy. The client was in his early 30s. He was a union laborer. He was doing work on the ground level. It was a multi-level construction project. At the time of the accident, he was bent over. He was crouching, working on a wall. They were doing demolition on the level above him. They failed to ensure that there were no workers below where they were working, and they failed to safe off what they call a drop zone, so that when they're doing demolition at the higher level, as they remove materials, they can throw them into a safe drop zone. Obviously, for that drop zone to be safe, there can't be any workers there, and they failed to ensure that that was the case here. This worker was hit by a 2x4 that was thrown down from a height. He ended up with injuries to his lumbar spine and had surgery on his lumbar spine, which unfortunately didn't really go particularly well. Fusion surgery in the lumbar spine, there's a range of outcomes, and unfortunately this worker didn't have a very good outcome. So he was left with permanent pain and limited mobility, in the sense that he couldn't bend normally, he couldn't use his back the way a man of his age should be able to. For this worker, he lost the mobility, but unfortunately he didn't gain as much stability as was hoped for by the surgeon. So he was left with pain and limited use of his back, despite the fact that he was in his early 30s. One of the things that the defense raised, which, as I said, they almost always do, is that he had degenerative changes in his spine before this accident happened. It's a really common argument, a way of saying, well, it wasn't this traumatic insult that caused this need for surgery, it was underlying degenerative changes. You know, we always meet these arguments head on, and what we do is, starting in jury selection, as we did in this case, we talk to the jury about the idea that this is a man who works for a living. This is a man who uses his back to support his family every day. Wouldn't you expect that his spine would show some wear and tear given the rigors of his occupation? When the time came at the end of the case, it's great to be able to sort of loop back to something that you've established from day one. When they do hear it, you know, they can sort of say, oh yeah, that's right. They told me that I should expect that he would have some degenerative changes because he's a hardworking guy who uses his back all the time. And I remember getting to that point in summation and feeling the jurors agree and acknowledge that, yes, this is something we knew was coming and we understand where this argument fits in. And then, you know, I remember saying to them, what's really the argument anyway? Because he has degenerative changes in his back, it's okay to hit him with the 2x4? This was somebody native of Kosovo. Soccer is the biggest sport culturally for this person and for most people where he's from. He had young children, and he always imagined being able to teach his kids how to play soccer, and he himself still loved playing soccer on the weekends and was never able to do that again after this accident. Think of the photo album that never gets filled for this man. He's never going to have pictures in a photo album of him playing soccer with his friends again. He's never going to have pictures of him teaching his children how to play soccer. There are going to be empty pages in that photo album where there should be pictures of him with his daughter on his shoulders walking through Disneyland. The client testified through an Albanian interpreter, but when I met him, I felt that his English was strong enough that he could testify in English, and I thought it was really important to allow him to connect to a jury that way. And part of the reason was that by appearance, he was this big, imposing, burly construction worker, but he was incredibly soft-spoken, and you sort of could hear that he was wounded from the accident, and there was almost like this quiet desperation in his voice when he talked about where he was in life since the accident. So not only did I have to give this particular client all the assurances necessary that we were going to walk him through the trial process, but for this particular client, not only did he have to go into a courtroom for the first time in his life, not only did he have to speak to a room full of strangers about deeply personal things, not only did he have to have his integrity questioned and challenged by lawyers on the other side, but he also had to do it in what was not his native language. We actually brought a piece of wood into the courtroom about the same size as the piece of wood that hit him. Obviously, it wasn't the exact same piece of wood, but we had the dimensions. We brought it in, and it was really effective to have that in the courtroom every day, to be able to say it's not some trivial little splinter that hit him. It's this 6-foot 2x4 falling from a height that's higher than the ceiling in the room that we're in when we're in the courtroom. That gave the jury sort of a visual connection to the dynamics of the accident. The most effective moment for me personally in the trial, where I felt the most momentum, so to speak, was when the defendant's spine surgeon was on the stand. They had a very qualified spine surgeon who had examined the client and prepared a report that obviously was favorable to the defense. But when I was cross-examining the spine surgeon, I was able to get certain concessions about what we talked about the fact that there was nothing that appeared on any film from which this spine surgeon could say those degenerative changes would have caused symptoms. And at the same time, he had to agree that the traumatic insult this client suffered absolutely was a competent cause of traumatic injury to the lower back. And he had to agree that the diagnostic testing post-surgery did suggest that his lumbar spine was not properly fused and had not been ideally stabilized as you would hope it would be. Once their surgeon made those concessions, that was a really strong point for us. Another really strong point for us, really strong, was that the defense hired a radiologist who wrote a report that was actually pretty favorable for us. He again admitted that there were really minimal degenerative changes and that there were new findings diagnostically following the traumatic insult that had to have been caused by trauma. So the defense decided they were not going to call that doctor, obviously because his testimony would have been damaging to their case and helpful to our case. They hired a new radiologist. So every single doctor that came into the court, the doctors we called and all the doctors the defense called, I cross-examined them about that first defense radiologist's report. At the end of the day, I was able to say to the jury, the most important doctor in this case is the one the defense didn't let you hear from. So liability was granted based on a violation of Labor Law 240. When Labor Law 240 is violated, that's absolute liability against the owner of the property and the general contractor on the job. Both past and future medical expenses, past and future lost earnings, which included not only his wages, but also union benefits that he received, also past and future pain and suffering. There's really nothing like when a jury comes back with a verdict that essentially tells that injured worker, we see you, we recognize you, we understand that everything you've been through is real. This case offered that closure to this particular worker and his family. The final verdict amount was $6.7 million, I believe, but we had entered into what's called a high-low agreement before the verdict came back. This happens sometimes at trial where while the jury's deliberating, two sides can come to an agreement where essentially you agree to a low amount and a high amount to fix the range. So in this case, we entered into a high-low agreement. It offers protection to both sides. I think in this case, the range was 2.5 to 6.5 million. What that means is that in the event if the jury were to come back with a number less than 2.5 million, then the plaintiff is guaranteed 2.5 as a minimum. So it offers that protection to the plaintiff. For the defense, it offers them protection on the high side. If the jury were to come back with a verdict more than 6.5, the amount is fixed at 6.5. So the jury actually did come back with an amount a little bit over 6.5, but as part of the high-low agreement, both sides agreed that there will be no appeals and no post-trial motions made to the trial court. So the difference there is if there hadn't been a high-low in place and we have a verdict of 6.7, in all likelihood the defense is going to make a motion to the trial judge to reduce the verdict, which the trial judge may do. And no matter what the trial judge does, the defense is then going to take it up on appeal. The appellate court may reduce the amount, and either way the client's going to have to wait what could be 2 more years. So the high-low agreement, it gives assurance and it eliminates the appeal process, and the client received what was life-changing money within weeks of the verdict. since the verdict, although he's not physically able to do construction work anymore, he now has the financial means and he's invested in buying homes and then overseeing renovation projects of homes and then reselling them. I was blessed enough to see him maybe about a year after the verdict, and it was like looking at a different person. He walked into the office with a big smile on his face. None of the worry that I really had come to think was just his normal facial expression, because I only knew him through the trial process. But just to see that light in his eyes and to hear him talk with such enthusiasm about undertaking these renovation projects of homes, it was beautiful to see. The trial process is always daunting, and anytime we talk to any client about the possibility of either resolving a case or that case going to trial, we always have an ethical duty to explain all of the risks and all of the pressures that go with trial. But when there's a successful outcome, like there was in this case, when you can see somebody's life transformed and you can see that moment when they understand that a jury recognized just how much they've suffered and they walk out of that with what really presents new opportunities in their life, then we know that we really have done what we're called to do.